Hello, welcome to AUSVEG and its members. This is a presentation by the Australian Industry Group, implementing new workplace relations obligations. My name's Paul Borobocus. I'm Special Counsel Principal Advisor with AI Group Workplace Lawyers. Today we're going to be going through the last wave of legislative reform to the Fair Work Act. We're going to be covering a number of items, including the definition of employee, the new provisions related to casual employment, the provisions related to labour hire, same job, same pay orders, the amendments to the flexible working arrangements, the provisions related to the right to disconnect, and the limitations around fixed-term contracts. There's quite a bit of material involved. The slides are comprehensive and include quite a bit of detail. I don't intend to go into each slide, chapter and verse, but rather make mention about the salient points regarding these changes. Just to go back in time a little bit, under the Albanese government, there were four wave of reforms. The first being the secure jobs, better pay, and the second being the protecting worker entitlements. And then we had closing loopholes in 2023 and a second wave of closing loopholes, number 2 Act in 2024. And these are the changes that we'll be covering today. For members of the Australian Industry Group, you can access additional information by going to our website as shown on the screen there. Okay, going straight into the first change to the Fair Work Act under the last wave of reforms, and that includes the definition of employee. There's a new meaning of employee and employer in the Fair Work Act based on the real substance or the practical reality and true nature of the relationship between the parties. So what that means is that when the Fair Work Commission or a court evaluates the relationship between the worker and the business or the company, what's looked at is the totality of the relationship between the parties, the terms of the contract, but also other factors relating to the totality of the relationship, for example, how the contract is performed. Under this new relationship definition, the terms of the contract are no longer definitive. Prior to these legislative changes, there was a High Court decision which focused on what the terms of the contract were. This is no longer exclusively the case. We've put a table out here explaining what is an employee and what is an independent contract, and itemised the various factors that indicate one or the other. I don't intend to go through them in a great deal of detail, but a couple of the more salient things is what's looked at is the degree of control exercise. That is, the more control by the employer, the more likely it's going to be a employment relationship. For example, directions around how to perform the work, the hours of work, whether the employee can take public holidays, who deducts tax, whether there's an obligation to work, or whether the work can be delegated. These are the sorts of indicia that the Court and the Fair Work Commission will look at. There's certainly not an exhaustive list, but certainly weight is given to these factors outlined here. We've also pointed out some decisions that are commonly referred to in assisting what is an independent contractor or an employee. I won't go through this in detail. It's there for you to read through. But essentially, Hollis and Varbu and Stevens and Broadbeck are two of the key decisions. So what does it mean for your existing contractors? Well, the new definition applies to relationships entered into before the 26th of August 24, if the relationship continues beyond that date. So it's important to note that the contractor must be an individual and not a proprietary limited. So if the status is that the contractor was engaged before the 26th of August, then the determining factors as to whether they're an employee or a contractor will be based on the previous High Court test case, the two previous ones that I mentioned earlier, including. But if the status is that the relationship was formed after the 26th of August, then the determination as to whether they are an employee or an independent contractor will be based on the new statutory test. There's potential for contractors to avoid being deemed employees under the new definition through what is called a opt-out mechanism, where the contractor needs to be earning higher than the threshold of $175,000 per annum. It's important to be aware that if you opt out now, the contractor may have been still deemed an employee from the 26th of August to the date of the opt-out notice provided. Also, if the contractor becomes an employee through the new test, then of course any industrial instruments such as an award or perhaps an enterprise agreement, if there is one, will apply to that individual. You should also note that the contractor can only opt out once and can only revoke the nomination once. There are some strict rules in the Fair Work Act regarding sham contracting. That is where employers engage in sham contracting where they mischaracterise or misrepresent an employment relationship as an independent contracting arrangement. There is a new stricter defence that the employer requires to prove that they reasonably believed that the contract was for services. There's a number of points here with respect to what is reasonable belief. Things that are taken into consideration includes the size and nature of the employer's enterprise and other factors such as the employer's skill and experience, the industry, how long the employee's been operating, whether there's any dedicated HR specialist or expertise in the business, and whether professional advice was sought from a lawyer or an industrial association. The penalties are significant for sham contracting. $469,500 is a maximum for most entities. We'll try and provide throughout these slides some practical tools as to what you need to do as a business. With respect to whether you have contractors or employees, we think you should audit your current contractor base. Have a look at whether there are any of these individuals likely to be deemed employees under the new test. If you have contractors who may be impacted by the changed definition, are they eligible to opt out? And also, importantly, you should audit your process for classifying workers when they commence to make sure that they're properly identified in the beginning as an employee or a contractor. And of course, always seek advice, and AI Group Workplace lawyers are well positioned to help you. We go into casual employment now, and you'll see that there is a new definition of what a casual employee is. The one that's been put into the Fair Work Act includes that A person is a casual employee if there is an absence of a firm advance commitment to ongoing and indefinite work, and the casual employee is entitled to a casual loading or a specific rate of pay for casual employees. The Fair Work Commission determines that the absence of a firm advance commitment on the basis of the real substance or the practical reality and the true nature of the relationship. And they do so by assessing, first of all, the terms of the contract, whether they're in writing or they're verbal, any non-contractual mutual understanding or expectation, and the conduct of the parties, including after the commencement of work. In other words, they look at what happens in practice, not just whether the employment contract states that they are a casual with a casual loading. It's important to be aware of the interaction between the new definition of casuals and any definitions included in an applicable award or enterprise agreement, as those should also be considered. So what is a firm advance commitment? Well, some of the things that indicate a firm advance commitment includes whether the employer elects to offer or not offer work. Can the employee elect to accept or reject the work? And is it likely, considering the nature of the employee's business, that work of this kind will continue to be available? And whether there's full-time or part-time employees performing the same kind of work as the casual employee. And also importantly, if there is a regular pattern of work for the employee. Now, this is a factor alone will not indicate whether there's a firm advance commitment, but all of these need to be satisfied. Sorry, all of these do not need to be satisfied, rather. So what does that mean for your existing casuals? Well, employees that were engaged as casuals before the 26th of August 2024 remain casual. And that is even in the case of their employment arrangements appearing more to be regular and perhaps systematic, and being inconsistent with the new definition. However, in respect of those ongoing existing casuals, any period of employment as a casual before the 26th of August is not counted for the purpose of calculating the periods relevant to giving of a employee choice notification. Also, the employer obligation to make an offer of casual conversion or give a notice of no offer of casual conversion continues to apply for a period of 6 months from the commencement, except, of course, in the case of a small business being less than 15 employees. And requests for casual conversion, if indeed they apply, continue for 12 months for the small business employer and 6 months for all other. So it's not all bad news for employers and workers who want to remain casuals. If the employee is properly classified as a casual at the point of engagement, they will remain a casual until they convert to a permanent, having made a casual conversion request, or if the Commission makes an order following a dispute which converts the casual to permanent, or the employment status is converted to permanent under the terms of an enterprise agreement or an award. Or the employer makes an offer of permanent employment to which the employee accepts. So it applies irrespective of whether the circumstances of their work change such that they no longer meet the casual definition. However, we want to note that if the employee was incorrectly classified as a casual upon commencement, it will have been a permanent employee from the onset and can make a claim for unpaid entitlements. which are of course subject to offset against the casual loading paid. We've outlined here, and I don't intend to go through in detail, the employee choice notification. That is where the employee makes a request for a casual conversion. Importantly, refusing the request, the grounds for an employer include that the notification may have been made incorrectly, that the employee's current employment relationship meets the statutory definition of a casual employee, or offer of permanent employment will contravene a government-based recruitment or selection process, or the employer has fair and reasonable operational grounds for not accepting the notification. And of course, those interesting words, fair and reasonable operational grounds, what do they mean? Well, fair and reasonable operational grounds are defined as substantial changes would be required to the way in which work in the employer's business is organised, or there would be a significant impact on the employer's operations. Or there'd be substantial changes to the employee's terms and conditions, which would reasonably be necessary to ensure that the employer doesn't contravene a term of the Fair Work instrument, for example, an award or an enterprise agreement applying to the employee if they convert to a full-time or a part-time employer. For the purpose of substantial changes, it includes changes that would have a significant effect on the way in which the employee would need to work. Relevant for AUSVEG would be that a casual conversion to a permanent employee would mean that impacts include, adverse impacts include missing out on being able to respond to seasonality for picking and packing vegetables. If there's a dispute, of course, if it's unresolved at the workplace, goes off to the Fair Work Commission, where in the first instance it would try to be resolved via mediation or conciliation. But then if it continues to remain unresolved, certainly the Fair Work Commission can arbitrate and issue orders. What happens if the casual is deemed as a permanent? Well, of course, they may be considered as misclassified and entitled to back pay, of course, subject to the offset against the casual loading. Important to remember that for medium and large business employers, before the employment commences or as soon as reasonably practicable, you should provide the casual with the information statement. The other thing we need to remember is that the casuals are sometimes put on fixed term contracts. There are limitations, and we'll go through those in detail shortly. But in essence, the maximum period of time that a fixed term contract can operate is 2 years, and the maximum time within that 2-year period that it can be renewed is once. So what should you do with respect to casuals? Well, of course, I think it's important to check your template casual contract. Make sure that it clearly states that they are for casual employment, that there is no firm advance commitment to ongoing work, and that the contract expressly states that there is a casual loading or a specific rate of pay for casuals. And also, you should plan and consider whether the casual may make a request for casual conversion. It's important to be prepared as to how to respond to casual conversion requests. Importantly, never commit to regular pattern of work, and don't ever make an undertaking that the work will be continuing and ongoing. We strongly advise that you ensure that you manage your casual population consistently with their casual status. So, for example, after a period of time, don't lapse into rostering arrangements, and ensure that your supervisors and managers are trained to ensure that the casuals don't work in accordance with fixed rosters. We go to fixed-term employment. In essence, there are new rules about using fixed-term contracts. As I stated earlier, employment contracts cannot have a fixed term if it's greater than 2 years, and the maximum period of time, the maximum number of times rather, that the fixed-term contract can be renewed for another period is once. But again, all the periods cannot exceed 2 years. What is considered a consecutive contract? Well, if they perform the same or substantially similar work. That is what you should consider, whether the person is employed in the same role or in the same capacity. The roles and the duties are substantially or in practice are the same. And whether the changes to the work are insubstantial or minor. Say, for example, in a manufacturing setting, a production worker on a packaging line performs 2 years in a fixed-term contract, and then is offered a further fixed-term contract in, let's say, another part of the plant. Arguably, it might not be substantially different or sufficiently different to permit that second fixed-term contract. However, should the packaging employee commence on a fixed-term contract for the same employer, but in reception, for example, that certainly wouldn't be considered substantially similar work. We've noted here some exemptions. Importantly for AUSVEG would be the essential work exception. That is where the employer needs additional employees to do essential work during a peak period. For example, seasonal work, fruit or vegetable picking would be included. There are anti-avoidance provisions in the Fair Work Act. Importantly, that a fixed-term contract would be considered invalid, but the rest of the contract would remain. That is, only the fixed-term contract provision would be considered invalid. The rest of the contract of employment would be considered a permanent and be entitled to relevant safety provisions such as notice, redundancy entitlements, and even access to unfair dismissal. What to do? Review your fixed-term contracts across your business if you do indeed use them. If you engage fixed-term contracts, review whether your use is within the restrictions. If not, we strongly recommend you update your practices. Skipping on to the labour hire provisions, otherwise referred to as same job, same pay. There's a number of slides covering this complex amendment to the Fair Work Act, but I think we can pretty much capture it in this slide here. Essentially, same job, same pay provisions is covering the typical or the traditional labour hire arrangement. That is where a worker or an employee is hired by a labour hire company to then go out to a client, otherwise known as a host, to perform duties. And this scenario covers a situation where the host has its own directly engaged employees performing the same work as or substantially the same work as the labour hire employee. In this scenario, an employee or a union can make an application in the Fair Work Commission to get an order requiring the labour hire provider to pay its employees no less than the host is paying its own employees. And of course, the order can only be made where an enterprise agreement applies to the host employees. That would also apply to the labour hire employees if indeed those labour hire employees were directly employed by the host. The work is for the supply of labour, not the provision of service. For example, a contract, a plumbing business wouldn't be included. Exemptions also apply to a small business employer. And in making an order, the Fair Work Commission must consider whether it's fair and reasonable to do so. We've set out a table here as to what is fair and reasonable. I don't tend to go through that in detail. Certainly, considering the time restraints, you can go through that material in your own time. But important to remember that this scenario really is only where the client of the labour hire company, the host employer, have their own enterprise agreement. Flexible working requests. There's a couple of changes there. We'll consider them minor and major. In terms of the minor changes, there's an expansion of employees who can make a request under the NES for flexible working arrangements. The new categories include employees where the employees are or a member of their immediate family or household experiences family or domestic violence, and also pregnant employees. We've set out we've set out the process here for you regarding responding to a flexible working request. It is what we consider to be a major change in the process, one that requires responding to a flexible request within 21 days of a written request. The employers must, first of all, discuss the request with the employee. You also have to have regard to the consequences of any refusal for the employee. You've also got to genuinely try to reach agreement about accommodating the employee's circumstances and inform the employee of any alternative working arrangements that could be made to accommodate the employee's circumstances. And you provide the employee with written reasons for any refusal. They must be on reasonable business grounds and must include specific information. It's important to get this right because the document could be used for the basis of a dispute in the Fair Work Commission. Do we have to agree to a flexible work request? Well, look, there are grounds upon which a refusal can be made. Employers are able to make a refusal to a request where it has reasonable business grounds for doing so. Just touching on what reasonable business grounds includes is the salient ones, rather, that it might be too costly for the employer. There's no capacity to change the working arrangements of other employees to accommodate the request, or that it be impractical to change the working arrangements of other employees or recruit new employees to accommodate the request, and that the new working arrangements requested would be likely to result in significant loss or inefficiency or productivity. And also that the new working arrangements requested would be likely to have a significant negative impact on customer service. When you consider reasonable business grounds, you should have regard to the specific circumstances, including the nature and the size of your business. Where the request is refused, of course, the matter can go off to the Fair Work Commission, where ultimately it can be arbitrated. I don't intend to go through this in detail, but we've outlined here some examples regarding flexible working requests in action. I can certainly let you read those in your own time to give you an understanding or a flavour of reasonable requests. Importantly, review your flexible working policies and procedures if indeed you do have them. We think it's an important policy to have covering off these days so that you're able to have a set standard policy approach to flexible working arrangements. The right to disconnect that you may have read in the papers was a provision that was included in the reform quite late in the piece and took quite a few employers by surprise. Essentially, the right to disconnect is where an employee's refusal is reasonable to monitor, read or respond to contact or attempted contact from their employer or a third party, work related of course, outside working hours. The matters that will be considered in determining whether the refusal is reasonable include, and this is not a comprehensive list, is that the reason for the contact or attempted contact, for example, whether it's an urgent matter or an emergency, how the contact is made and the level of disruption, the extent to which the employee is compensated or not compensated for the fact that they may be required to respond outside working hours, the nature of the employee's role and the employee's level of responsibility and the employee's personal circumstances, for example, which includes family and caring responsible. Importantly, it doesn't mean employers can't contact their employees outside of work hours, but if they do, the employee may reasonably refuse to respond. The right to disconnect is included in modern awards. It applies from the 26th of August 2024, or in the case of small businesses, 26th of August 2025. The model term prohibits an employer from directly or indirectly preventing an employee from exercising their right to disconnect under the Act. This is important because it's now a workplace right, and employees can make an application under the general protection provisions where they believe the employer adversely impacted their employment on the basis of exercising this workplace right. Where the parties have a dispute with respect to an employer's reasonable refusal, the Commission may resolve the dispute. The Commission may make an order to stop refusing contact or stop taking certain actions. Also, deal with the dispute except it cannot order a pecuniary payment. Be aware that enterprise agreements may contain a right to disconnect. which may be more favourable than the award terms. And certainly in that case, the term of the agreement, if it's more favourable, would apply. What you should do, we think, is identify roles where people in your business may be required to work or be contacted outside of hours. Where out-of-hours work contact will be required, I think it's important to update the employment contracts to reflect the requirement and the fact that employees' remuneration reflects this obligation to respond to contact out of hours, included in your position descriptions as well. And also consider what's included in the Code of Conduct and general policies. Do you need to reference expectations regarding flexibility? And also provide training to your managers and supervisors and employees on the right to disconnect and what it means, so that you can prevent an instance of breaching the general protection provisions in the Fair Work Act. What we've also done here is provided some slides regarding a framework for operationalising the changes. We understand that there are a significant number of changes and they're complex, particularly when we consider the multitude of changes that have come into operation under the Fair Work Act from the very first wave of changes. You can get information from AI Group's website. You can certainly, members, contact the workplace advice line and also be referred to AI Group Workplace Lawyers for assistance. But what we've also done here is provided some guidance around how to treat or how to respond to or view the changes that have been implemented, and we've done those under a series of categories. In the red, of course, category 1, it covers changes which impact all employees that you absolutely need to know and you need to act. For example, the right to disconnect, the prohibition on pay secrecy. The list is there for you to go through in your own time. The second category are, of course, changes to the Fair Work Act, which impact some employers rather, that you need to know if impacted and act. The third category, we consider these are changes to the Fair Work Act that are good to know, but you don't have to take any immediate action. And of course, the fourth category there are changes which are for information only and no action is required. Also, in considering these comprehensive changes, we think it's important that you go through your policy documents, your procedures, your employment contracts, particularly with respect to independent contractor arrangements, examine your enterprise agreements and your template employee communications. It'll be an important exercise to make sure that you are compliant. We think you should also prioritise what you need to do. On the top of those priorities is change has already commenced and that you're non-compliant. Say, for example, with respect to employees and independent contractors. If you suspect that your independent contractors that have commenced recently could indeed be employees and you're not compliant, we highly recommend that you undertake an audit. High on the priority are changes which will commence and will have significant implications, and also changes that have already commenced, and a watching brief or a proactive consideration should be undertaken. And then, of course, we have the moderate and the low level, that is for change assessed as lower impact, and change will not lead to an automatic state of non-compliance or significantly change risk profile on commencement. And of course, those low ones there are good to know for the future. We've also given you an example here about how to arrange and prioritise the areas of changes. I won't go through that in detail. It's there for you to work through. And of course, one more thing, and that is that the legislative reform ensures that all disputes end up being determined at the Fair Work Commission. In many cases, the dispute will go through a mediation or a conciliation process first, but then, of course, the Commission, in many of these cases, has power to arbitrate, issue orders and determine the outcome. Overall, though, you're right to be thinking that these changes are designed to ensure that the preeminent or the principal or the main, if you like, type of engagement that the Fair Work Act is funneling is that of an directly employed permanent employee by an employer. The Fair Work Act changes seem to impose significant limitations on a range of different types of employment models, labour hire, casual, and independent contractors. So you're certainly right to be thinking that the overall purpose of these changes is to try and ensure that employers engage workers as direct permanent employees. Certainly, we're the view that there are options for employers, and we're happy to provide you with advice. Please reach out. Thank you for your time, and thank you to Lucy for your invitation to present to AUSVEG.